and so it's nice to see that we have standing room only. I would especially thank Americans United for Separation of Church and State, the ACLU, the Human Rights Campaign, for holding this briefing on the Do Not Harm Act. I want to thank Congressman Kennedy for his leadership on this particular issue. But religious freedom is a fundamental American value, but we must ensure that it's working to protect rights and not used to inflict harm on others. When we originally passed the Religious Freedom Restoration Act, or RFRA, in 1993, we did so in a bipartisan fashion to make sure that everyone's rights were protected. It was done to protect religious liberty, but unfortunately, rather than the shield to protect people's rights, has been used as a sword to actually inflict harm on others. This administration, in particular, has eroded civil rights protection under the guise of RFRA by denying LGBTQ Americans their rights and liberties. It's a fine line when you start talking about religious liberties and give you an excuse to discriminate based on religion. It's hard to differentiate that from racial discrimination, particularly. I don't know about where you come from, but where I come from, there are a lot of churches where the membership to the nearest percentage is 100% black or 100% white. And so if you're discriminating based on where you go to church, that has other implications. Furthermore, when you allow people to discriminate under this and charitable choice, you get federal programs being administered in a discriminatory fashion. There's a group in South Carolina that got a contract under the HHS to do adoptions, and they have announced that they're only going to consider for adoptions good Christian families. I guess if you go to the right church, you can adopt somebody. If you don't, you go somewhere else to adopt somebody. And that kind of discrimination used to be kind of perfunctory illegal. I mean, you don't have to think much about that, but now because of the misapplications of RFRA, we're having to deal with those kinds of questions. One way we can deal with it is you get all your religious freedoms, but you cannot inflict harm on others. You can't use it as a grounds for discriminating against somebody. And that's, I think, would eliminate a lot of the problems with RFRA. And so simply put, if you can have RFRA, but if we can pass the Do Not Harm Act, we can ensure that no one can use the religious laws to skirt the guarantees of basic civil rights laws. You don't get to, because you just have strong feelings about it, get to decide which civil rights laws you're going to comply with. It used to be if you had problems with some minority group, well, that's your problem. That minority member has a right to be in your restaurant, be in your hotel, or anything else. And so RFRA has started complicating this, and even in federal programs. This bill wouldn't be possible without the distinguished leadership of the gentleman from Massachusetts, who has been a fighter for not only religious freedom, but civil rights generally. So let me welcome to speak the gentleman from Massachusetts, Joe Kennedy.
Good afternoon, everybody. I will be short, and I will be short. Trying to make sure to get to the extraordinary panel of experts here that can fill in some of the details of this bill. I'm going to say a couple things. One to start. First, I'm so honored to be able to continue to lead this bill with Chairman Scott. I'm so honored to call him Chairman. This has been, as I think some of you in this room know, certainly the folks on the dais and here, this bill was first introduced nearly 5 years ago. And it took an awful lot of effort to dive into the nuances and to try to strike this balance, I think, correctly. And it was an awful lot of effort from an awful lot of people to try to make this work. The legislation upholds a fundamental basic principle that this country was founded on, the idea of religious liberty and the idea of religious freedom, and the need for the Religious Freedom Restoration Act to help guarantee that value and that right. However, as Chairman Scott said, we have seen a transition over the course of recent history from the use of RFRA as a shield to protect one's religious practice to a sword to be able to use my religious beliefs to impact your access to fundamental basic civil rights. And this law, Do No Harm Act, simply states that you cannot use your religious beliefs to inflict harm on those bedrock fundamental values of another person. It gets back to the fundamental balance about that the Constitution hopes to strike, and that we have seen, I think, eroded over the course of recent history. Chairman Scott has dedicated his time in Congress to these issues. I'm honored to be able to do this with him. Veronique did an incredible job working with a former staff member of mine for countless hours going back and forth over drafts of this years ago. And we're grateful for all that you have done as well to make this work, and my team currently, Tice, as well. Let me say very briefly, and then kick it to the experts here to flesh out some additional details. That transition back to ensuring RFRA acts as a shield and not a sword, the legislation brings it down to 6 fundamental areas that we try to ensure that where religious freedom cannot be used to impact the rights of others. 1, non-discrimination laws. 2, workplace laws regarding wages and compensation. 3, laws regarding children's welfare. 4, laws ensuring access to health care. 5, the provision of goods and services under government grants and contracts. And lastly, the provision of government services themselves. Try to make sure, again, that the exercise of one's religious belief cannot be used to impact the rights of another American as they fall under those 6 categories. Also, and this is critical, the Do No Harm Act restores, clarifies the ways in which RFRA can be used to claim religious exemption. And it restores that balance by saying RFRA can only be used in circumstances where the government is a party to the lawsuit. So it can no longer be used in federal court to try to claim action between private parties. But RFRA can be used on when it is government action that is being alleged that infringes on religious exercise, not the action of a private individual working in a private practice. So with that, I will kick it over to our panel of experts. I can get into the deeper reads on this. The 3 folks that you have before you have been extraordinary, and organizations that they represent have been extraordinary allies in trying to strike the balance that we sought to keep, or that we sought to arrive at. Maggie from Americans United has been right there on the front of this for years, and we are grateful. So thank you very, very much.
And I just want to thank both of you for spending time with us here today to talk about this issue, and for your years of leadership on this, for your sponsorship of the bill, and your dedication to these issues that are important to so many people. So we are going to go through a couple of things today. Our goals are to talk about RFRA. Oh, thank you. To talk about RFRA, where it came from, what went wrong. To talk about some of the Trump policies that are based on this misinterpretation of RFRA that we have now. Hear a little bit about the faith perspective. Sometimes you hear that RFRA is promoting religious freedom when it's really actually promoting religious discrimination at this point. And then talk a little bit about the Do No Harm Act. Luckily, we have Robin Merrill, who is the Associate Legal Director at the Human Rights Campaign, and Naomi Washington Leapart, who is the Faith Work Director for the National LGBTQ Task Force. Ian Thompson from the ACLU was supposed to be here today. He can't be here, so I'm going to do my role and his role. So I apologize, I'm going to be talking a lot. We also want to thank all of you for being here, for caring about this issue, and for learning more about religious freedom, RFRA, and the Do No Harm Act. But before we go into the directives and the constitutional principles and the regulations and the guidance, I want to talk about a few people, because I think that when we're really talking about this issue, what it really comes down to is how people are affected. So I want to talk about Amy Madonna. Amy Madonna is a Catholic married woman, has 3 children, and she grew up in a home with many foster brothers and sisters in foster care system. And she now wants to open her home to kids in the foster care system as well. So she decided to go to the local foster care agency and volunteer in the hope that she could find a good fit for her family and then foster a child. And she was excited when she went to Miracle Hill, and she thought it was going to be a great fit, until she found out that they thought she was unqualified. Why was she unqualified? Because she's Catholic. They say they will only work with certain evangelical Protestants. And of course, this discrimination violates federal law, but the Trump administration is using RFRA to provide her with a religious exemption, or to provide, Miracle Hill with a religious exemption, so that they can discriminate against people like Amy Madonna. I also want to talk about Alan Yorker. Alan Yorker is a psychologist who had applied for a government-funded job at a children's home in Georgia. This was several years ago. He was qualified for the job, qualified enough that he got called back for an interview. And when he went in to talk to the person for the interview, they looked through the form, and when they saw that he wrote down that he was Jewish, they said, "Oh, I'm really sorry, we don't hire Jews." Now, this was a government-funded program. It was a state-funded program. And so Alan Yorker stood up and he sued them. And the case was ultimately settled in the state of Georgia. But that is exactly what the Trump administration is doing right now with RFRA. And Rob is going to talk a little bit more about that. But that's what they're doing. They're using RFRA to allow discrimination like would be against Alan Yorker. And I also want to talk about one more person, Samantha Coyle. She's a trans woman who found herself homeless and needed a place to stay. So she went to the local shelter, which was state-funded, and they claimed a religious exemption to turn her away. And so she actually ended up sleeping in the forest because she had no place to go. And there are press reports that HUD was inspired by this. Now, you hear that story and think they were inspired to prevent this kind of discrimination with federal funds. But no, they were actually inspired to pass regulations to make sure that other homeless shelters could use taxpayer dollars and turn away people like Samantha Coyle. So that's where we are right now. And these are all cases where they are misusing RFRA to discriminate and harm other people. And this is not what RFRA was intended to do. As Chairman Scott mentioned, RFRA came about after the 1990 Supreme Court decision, Employment Division versus Smith. So in this case, they really changed free exercise jurisprudence. In the past, there had been a strict scrutiny test where they would ask, is there a substantial burden on religion? And if there is a substantial burden on religion caused by the government has to show that they have a compelling interest to place this burden on the person and that the law is narrowly tailored. But in Employment Division versus Smith, a Justice Scalia case, they actually changed the law and they said, actually, no, if the law is neutral and generally applicable, then there's no First Amendment claim. So there were a lot of people who thought this was really troubling. This is a huge change, and we were really concerned about the rights of people who are of minority faiths, primarily. And we wanted to return the pre-Smith jurisprudence to First Amendment law. And so what we did is, I didn't. In 1993, Congress passed RFRA. And the idea was to protect people in situations like a Jewish student who goes to public schools and there's a no hat rule and they need to wear a yarmulke. They wanted to make sure that they could get an exemption. Another situation that was discussed during the congressional debates is a dry town. And there's a church and they're prohibited from having communion wine. So they wanted to protect things like that. So RFRA passed, and though people think that it took a really long time for the coalition to break down, it actually broke down kind of quickly over some attempts to use RFRA to discriminate. But the turning point really was the Bush administration, the George W. Bush administration. And they adopted an Office of Legal Counsel memo that essentially addressed the Alan Yorker scenario. And they wrote this memo and they said, RFRA can trump federal non-discrimination law. So if you are a taxpayer-funded agency and you get money, you can prefer people of your own faith and discriminate against other people. This totally misinterprets RFRA, and it totally ignores the Establishment Clause limit that says that you can't provide religious exemptions when they're going to harm other people. So we started with that. And then in 2015, the Supreme Court issued an opinion in Hobby Lobby versus Burwell. And that also distorted RFRA. So what happened in that case is the Affordable Care Act requires that employers who are providing health insurance have to cover contraception with no cost sharing. And when they created this law, they also put out a regulation that said houses of worship don't have to provide this insurance. But if you're a religiously affiliated nonprofit organization, you get what they call an accommodation. And the organization didn't have to provide the insurance, but they would just fill in a form, give it to the government, and then the insurance company would provide the insurance. So the employer didn't have to talk about it, they didn't have to pay for it, they didn't have to provide it, they really had nothing to do with it. But the women get the health care that they need anyway, the coverage for it. But Hobby Lobby walked in, and they're a large for-profit craft store that employs 32,000 people, and they argued that they also deserved a religious exemption because the owners claimed that it violated their religion to provide coverage for contraception. And in an unprecedented ruling, the Supreme Court sided with Hobby Lobby. This was the first time that a court had applied RFRA to a for-profit corporation. They also sort of tinkered with the test. They made it very easy to prove a substantial burden, and they made it very hard for the government to prove that the law was narrowly tailored. And what happened here actually is that the accommodation came back to bite the government. They're trying to give a religious exemption. And the court said, well, if you gave a religious exemption to the nonprofits, then you can give the religious exemption to the for-profits. And so that is the way that the court ruled. So that's sort of where we left off, and that takes us to the Trump administration. And I'm going to just talk about one more thing. I'm just going to mention sort of the next step of what happened with Hobby Lobby, and then I'm going to pass it to Robin to talk about some other things. But one of the first things that the Trump administration did in this area is they actually extended the religious exemption in the Hobby Lobby case. So the court had held, well, since there's this accommodation and women are still getting health care, then, we're going to allow this accommodation to stand under the Constitution. But what the Trump administration did is they walked in and they had an even more extreme version of an interpretation of RFRA, and they said all non-governmental entities, so all employers, whether it's a university, a nonprofit, a for-profit, can take a religious exemption. Essentially, you just say that it violates your religious beliefs, and you get out of it. And the shocking part is they got rid of the accommodation. So the part that really that was like what the Supreme Court decision was hinging on, they got rid of it. So now your for-profit employer can claim a religious exemption, deny you insurance coverage for birth control, and you don't have this accommodation that allows you to get it anyway. This regulation, there's several lawsuits, including one by Americans United, the National Women's Law Center, and the Center for Reproductive Rights on behalf of students at the University of Notre Dame. And it's currently blocked by the courts. But that is one of the first things they did. So another extension of RFRA, and this time to take away your access to health care.
More good news. Hold on. Good afternoon. I'm so glad to see such a full room here to talk about this. As Maggie was mentioning, the Trump administration really amped up using RFRA as a sword, which it absolutely was never intended to be. It was designed to protect minority religions from overburdensome and unwanted government intrusion. And as Maggie says, it has been reinterpreted to protect not just people, but entire huge corporations. And the Trump administration has absolutely glommed onto this and promoted this in an extremely systematic way. And one of the ways that it did this was actually by publishing a 25-page guidance document in October 2017 that details in sort of a bullet-pointed way a list of sort of questions and answers about how RFRA actually is amazingly expansive and flexible and can be used in all sorts of ways to get around non-discrimination laws, basically. So as part of this, federal agencies were also given a mandate to go through and look at their regulations and make sure that they were in line with this guidance and were really in line with this new vision of RFRA. And unfortunately, that is what we have seen happen. One example is out of the Department of Labor. We saw a directive last August come out from the Office of Federal Contract Compliance Programs, OFCCP. And OFCCP is the body that monitors basically all actions that federal contractors take. Because federal contractors are a huge part of the way the American workforce works and where our tax dollars go are to federal contractors. And so OFCCP monitors discrimination in a really interesting and thoughtful way with data to make sure that people that take taxpayer dollars to do work on behalf of you don't discriminate. And this executive order was actually signed in 1965, and then it has been amended over time to include more communities. And then finally in 2014, it was amended to provide protections for LGBTQ folks. Unfortunately, the Trump administration's directive in August expanded this idea of, expanded religious exemptions under the regulation. And, under the executive order. And I think it's important to note that in 1965, there were no exemptions. It was extremely straightforward. Do not discriminate if you're a federal contractor. In 2002, as Maggie was saying, under the Bush administration, things were starting to heat up. And the executive order was amended to have a fairly limited religious exemption that allowed contractors and subcontractors to discriminate on the basis of religion only. So we're trying to cabin it in that way. The Trump administration, what they have done, the August directive, and then what we now know has been moving through OMB and OIRA is a proposed regulation to codify this directive, absolutely expands, sort of blows up this religious exemption, just basically beyond recognition. And allows for sort of mandates OFCCP to make sure that contractors are allowed to discriminate on the basis of religion in hiring. And I think it's important to note what does on the basis of religion mean. Unfortunately, it means a lot, and it means not only religious belief, but religious tenet. Basically, if you are not, as Congressman Scott was referring, a good Christian, the right kind of Christian, even if you go to church all the time, at the right church, if you, for example, are in a same-sex marriage, that could mean that you're not the right kind of Christian for them. So, I would also just note that this guidance is, I really urge you to look at it, because it is completely a misstatement of law. I'm really into the rule of law these days, hashtag rule of law. And the OFCCP guidance is just, it manipulates 3 big court cases and uses them in a way that is actually just wrong. It uses Hobby Lobby to say that you should be able to discriminate in employment, when Justice Alito explicitly said, by the way, my decision might be different if this was talking about discrimination in employment. So that's a miss. And then also, it brings up Masterpiece Cake Shop case. Folks familiar? Yes. So it brings that case up as a reason why the Supreme Court says that you can discriminate in public accommodations. No, not that either. The Supreme Court didn't say that either. It actually did a very narrow decision and actually said, as a general rule, these objections don't allow business owners to discriminate. So, it's a bad policy built on bad footing, hashtag rule of law. We're also seeing this really pop up across the board, especially when you're talking about federal funding. You're talking about the most vulnerable folks often who are served by federal programs who are going to lose access. So, for example, it's folks accessing emergency shelter. We know that HUD has moved over a rule to OIRA that would revise the equal access rule to allow emergency shelter providers to take into account sort of a myriad of factors when determining where to place transgender folks. Instead of just their gender identity, they can consider a range of factors, including religion, which is, again, unprecedented. And then finally, I think we are seeing this across the board, but in healthcare in Section 1557 of the Affordable Care Act. This is a landmark civil rights provision, the first time that sex discrimination was prohibited in federal law in healthcare. It's been interpreted since 2011 by DHS, to include gender identity and sex stereotyping and many LGBTQ people under that umbrella. And the case was challenged under RFRA and the Francis and Alliance case, saying that a religious hospital organization should not have to provide equal services on the basis of gender identity or some reproductive rights services because of religious belief. The Trump administration chose not to defend the reg at all, and instead has issued a new regulation completely omitting protections from discrimination on the basis of gender identity and a lot of language access provisions as well. So we are definitely, agencies have definitely taken this 25-page guidance document to heart, and there's an interest to undo all of the good progress that we've done as thoroughly as possible, and as I would argue as insidiously as possible under the guise of religion.
I'm going to pop back in. And Ian was going to talk about the foster care issue, and so I'm just going to touch on that a little bit more. So I already told you the story of Amy Madonna, who was turned away because she's Catholic from a foster care agency. But she's not the only person who was rejected from this foster care agency called Miracle Hill Ministries. Beth Lesser and Lydia Curry are both women who wanted to volunteer, and they were told that because they're Jewish, they aren't qualified to be volunteers and mentors. And then there's also Eden Rogers and Brandy Welch, same-sex Unitarian couple who wanted to be foster parents. And they were also turned away. They were told it was because they're Unitarians, but the policy at Miracle Hill is also that they will not work with parents who are same-sex couples. So this is happening to a lot of people at Miracle Hill. So the South Carolina Department of Social Services got some complaints about Miracle Hill, and they decided to investigate. And when they investigated, they found that Miracle Hill was violating both state and federal non-discrimination laws that prohibit discrimination with government dollars. There's one particular HHS regulation that prohibits this kind of discrimination. So when South Carolina's governor heard this, again, instead of sticking up for these parents who are being turned away because they are Catholic or Jewish or Unitarian, he didn't denounce the discrimination. Instead, he took the side of Miracle Hill, and he issued an executive order so that he could sort of sweep away all of the state non-discrimination law. So under state law, it could be permissible for them to engage in this discrimination. But he realized, of course, that he can't himself get rid of an HHS regulation, and so he wrote to HHS and said, we think you should use RFRA to grant a waiver to all of the agencies in South Carolina. There have also been, since then, the AG and Attorney General in Texas has asked for this. Some foster care agencies in Pennsylvania have asked for this. And so it was on the desk of HHS for a long time, and then on January 23rd, 2019, the Trump administration granted the exemption to Miracle Hill using RFRA. So essentially what's happening here is that in the name of religious freedom, we are actually engaging in taxpayer-funded religious discrimination. The government should never fund discrimination. No qualified parent should ever be turned away because they are the wrong religion. But of course, really, the people who we should be most concerned about here are the children, right? There are children in foster care who just want a loving home. And instead of providing them homes, they are putting their own religious tenets and their own religious litmus test first. And so there are kids who could have a home with Eden Rogers and Brandy Welch, or perhaps with Amy Madonna and her family, but instead they are still in the foster care system looking for homes because their parents who were going to give them homes are of the wrong religion. The government, when they are serving children with government funds, have a duty to act in the best interest of the child, and this is not the best interest of the child. There are 2 lawsuits that are challenging this Trump waiver already. Americans United has filed suit on behalf of Amy Madonna, and then the ACLU, Lambda Legal, the ACLU of South Carolina, and South Carolina Equality Coalition have filed suit on behalf of Eden Rogers and Brandy Welch. All of these are taking place of discrimination in Miracle Hill. So those cases are right in the beginning, so there's no, they haven't gone anywhere yet. But despite this, we are hearing that HHS is looking to adopt this waiver that was sort of in a letter, and it's now policy into formal regulations that would apply not just to South Carolina, but nationwide. And so that is another reason that we need to do no harm act. And now Naomi's going to talk to us about the faith perspective.
Thanks, Maggie. So good afternoon.
Good afternoon. I am a pastor. I am a faith leader whose pulpit is in the public square. I have the pleasure of working at the task force with some of the best policy minds in the business. And so my introduction to this conversation was actually through a story about a woman named Tamisha Means. She is from my home state of Michigan, Muskegon, Michigan to be precise. She was 18 weeks pregnant in 2010, and her water broke. Now, this is not good. She began to experience contractions. And so she immediately goes to the nearest hospital in her community, a hospital called Mercy Health Partners. She was given pain meds, and she was discharged. She was told to return to the hospital for her regular appointment, which wasn't until 8 days from then. Tamisha didn't know that this hospital, Mercy Health Partners, was subject to a set of written policies called the Ethical and Religious Directives for Catholic Healthcare Services, ERDs, I'll call them for short. This set of directives was not written by medical professionals, medical researchers, scientists. This set of guidelines was passed down from the U.S. Conference of Catholic Bishops. They set the parameters for Catholic healthcare. And they say that they draw these parameters from the Catholic Church's theological and moral teachings. So the ERDs prohibit healthcare providers from delivering a range of services, a range of treatments, often without the patient's knowledge or consent. So Tamisha goes home. She's still in pain. She gets worse. And the doctors did not tell her about how she might avoid further complications by medically terminating her pregnancy. They knew the pregnancy was no longer viable, but they sent her home. The next day, Tamisha comes back to the hospital. She's still in severe pain. She's bleeding. She has a high temperature. The treating physician suspected that she might now have a bacterial infection, but she was discharged a second time without any explanation, without any indication about the gravity, the severity of her condition. Of course, Tamisha gets worse. She comes back a third time that same day. She was in the midst of being discharged a third time when she actually went into labor. The child that she delivered died shortly after. The trauma of this cannot be overstated. Tamisha discovered that Mercy was a Catholic hospital. Mercy abides by these set of directives, is angry, and partners with the Michigan ACLU to sue for neglect, willful neglect. The case gets all the way to the Michigan Supreme Court, and unfortunately, Tamisha lost her case. The court did not want to intervene in matters of religious doctrine. That was my introduction to this conversation. I sit here as a Black woman, an LGBTQ woman, who constantly experiences the anxiety of not knowing whether I'll be treated right. But I'm also a person of faith. I am also a religious leader. And I know what happens when faith gets abused in this way. And so I'm here to say that the set of guidelines, the ethic espoused by the set of guidelines, is not the ethic actually shared by most people of faith in this country. Contrary to popular belief, most people of faith in this country are actually against discrimination on any grounds. Discrimination against LGBTQ people, discrimination against poor people, discrimination against trans people, any people. It's troubling when people who live in bodies like mine can't find care and compassion and peace of mind even in a place like a hospital, where vulnerability is the status quo. We expect that at least in healthcare settings, understanding and concern for well-being can help to soothe the pains of everyday living. But these guidelines and other kinds of invocations of RFRA to discriminate by religion actually intensify the already chronic pain of being in a marginalized body in this country. Even beyond the humiliation, even beyond sometimes the physical risk that women, people of color, LGBTQ folks face when we are refused care, when we are refused service. We have to manage the task of being resilient, of going to the doctor again, of going to the hospital again, of trying again to get services that might be denied. These are like little paper cuts to dignity that contribute to a gaping wound. So, as a Christian minister who is deeply invested in the faith implications of this conversation, I want to offer that in addition to economic pain, in addition to physical pain, there's another kind of pain that is introduced when people are refused care, refused service, refused access. It's spiritual pain, and that's what's on my mind today. To be told that your healing or your protection is a violation of God's plan. To be treated as if you are inhibiting another person's ability to be faithful. These experiences inflict spiritual wounds that rarely go away. So I want to suggest that we also must do the work of preventing spiritual harm, spiritual malpractice. So we can't allow certain bodies to be sacrificed in order to bolster some people's sense of piety or religious devotion. We can't allow religion to be used as an instrument to control or regulate bodies that are considered offensive to some people. We cannot manipulate our laws to justify and sanctify this kind of perversion of religious freedom. As I said, I'm not the only one who feels that way. The Public Religious Research Institute has done the work, done the studies. A majority of religious people in the United States, 60%, actually opposed religiously based service refusals. I teach theology and peace and justice studies at Villanova University, and my students, many of whom are the next generation of Catholic lay and leaders, oppose this kind of use of religious exemptions. So that's good news. That's why we need the majority, this symphony of voices, to speak loudly in support of the Do No Harm Act. Religious liberty does not foreclose on LGBTQ liberation, on liberation for anybody. And faith cannot be used as a loophole that makes our contempt or our entitlements or our fears sacred or legal. I believe that faith is at its core aspirational. It is the evidence of what doesn't yet exist. So faith is not then a license to opt out. Faith is actually an invitation to opt in to what is not yet there. Opting in to serving people who might not be our friends yet. Opting in to caring for people we never thought we'd be concerned about. Opting in to relationship with people we wouldn't have met otherwise. And so faith must compel us to aspire beyond what now is. So I'm here as a person of faith, arguing on faith grounds that we must dismantle the idea that faith gives us the freedom to deny each other, to ignore each other, to leave each other at the side of the road. And so my work at the task force, in collaboration with the organizations represented here and others, is to also mobilize people of faith themselves to say, no, we won't allow this on our watch. And so I'm grateful to continue this work. I encourage you to think through how we fight this, not only on political and legal grounds, but on moral and spiritual grounds as well. Thank you.
going to do about it? The Do No Harm Act currently has 80 sponsoring organizations, 23 faith organizations, and the bill is very simple. It simply restores the Religious Freedom Restoration Act to its original intent and achieves what the bill was designed to do in the first place. It absolutely preserves the law's power to protect religious freedom, but also clarifies that it cannot be used to harm others. So, RFRA could not be used as a sword by others to undermine non-discrimination provisions, evade child welfare laws, allow for the refusal of performing duties as a government employee, denying access to health care, trumping workplace laws, and refusing to provide government-funded services under a contract. It's really cut and dry, it's really simple, and it's really important.
Does anyone have any questions? It's all simple stuff. Yeah.
So I have actually a question about.
Actually, can you also say who are you with? You're with an office or?
Sure, of course. My name is Amanda Smith. I'm with Representative Diana Bedette's office. So I have a follow-up question about the Hobby Lobby case. So within the decision-making process for the court and within the majority opinion that was written, they specified that certain medical needs could not be denied due to like a religious exemption, like inoculations and blood transfusions. And so I'm wondering, would it be possible for an individual or group to kind of attack that majority opinion and perhaps overturn it, because it could be argued that by saying this type of religious exemption is fine for medical necessities and then you cannot use religion to deny these medical necessities, it's kind of like the Supreme Court drawing a line on religion and what religion in this country can and can't do. And wouldn't that be inherently against the First Amendment in the government establishing a religion in the United States? Like, could that law and precedent be attacked in that way to start returning religious freedom to its place in the individual rather than in the power of a corporation?
So I think the question is, in the Hobby Lobby decision, they explicitly say that they wouldn't grant an exemption like this, religious exemption like this, if it was it was about blood transfusions, and I can't remember all the other ones, but yeah, inoculation. So I think the question is that actually preferencing one religious belief over another, because they're sort of you get the exemption if your religious belief is about not providing birth control. You don't get the exemption if your religious belief is about blood transfusions and inoculations. Sorry about it.
Yeah, well, that's the whole problem with it. They were sitting not as judges, but as council of cardinals, and deciding which religious beliefs they were going to accept. And you can only do that so many times. Well, you can't overturn the Supreme Court. I mean, that's the final judgment. But when they start deciding which religious doctrine they're going to accept, they're into an area that will ultimately make no sense from a legal point of view. And that's part of the problem. I mean, Jehovah's Witnesses feel just as strongly about blood transfusions as Catholics think about contraception.
Question behind you.
I was just wondering, you've given some great examples about different religious groups discriminating against the LGBTQ community and women who are trying to access contraception. But how far have groups like that tried to stretch those religious beliefs? What do they have to argue on their end to sort of convince the court that they are worthy of those exemptions?
So I think the question is,
what does the religious body or whoever's sort of on the other end of the case, what do they have to argue to prove that they have a religion? They deserve a
The
religion.
belief is sincerely held. The belief is sincerely held.
Okay.
Yeah. No, I mean, not much is the answer. And I think the court, the jurisprudence there, it gets tricky for somebody to try to ascertain whether or not a belief is sincerely held. It's not like there's a checklist versus the various ways in which you are a good Catholic versus a non-good Catholic or anything else. So the court, I think, rightfully starts to put some deference there to say, hey, if you say it's sincerely held, there's not a whole lot of evaluation you can do to get into the mind of somebody to say whether that is a sincere belief or not, which is also where this, I think on the one hand, rightfully so, on the other hand, this gets to be pretty amorphous, where you can just start claiming, oh, sincerely held belief, therefore no, and it just creates this massive exemption to civil rights law.
I just want to add to that what also complicates it is the access to power and resources to pursue a sincerely held religious belief is concentrated in ways in this country, if we're honest about it, right? And so it's that certain sincerely held religious beliefs get protected because the folks who hold them are able to access a degree of power, a presumptive kind of normality of that moral claim, right? And so back to the original point that RFRA was designed to protect folks who were vulnerable and part of religious minority communities who didn't have access to that kind of power in the public square. And so it's complicated by the way power is wielded currently in this country.
So when I think about topics like this, I think about a quote, my rights and where yours begin. And I'm wondering if you have seen or if you have any ideas on effective strategies where the person on the short end of this exchange might be able to use the same RFRA policies to argue that their rights are being denied by somebody else's claim to rights. And I think of, in a very limited scope, I think that the Satanic Church has done a little bit of that, but I think that they've kept it pretty confined and looking for something a little more broad.
So the question is, can sort of the people who are going to be discriminated against, can they chime in and say they actually have a religious freedom right or some sort of right that sort of use RFRA like in the reverse? I know that there are some cases like this, but the way that RFRA is set up, right, is you have to prove a substantial burden to your religion. So a lot of what's happening here, right, is it's people who have a religious belief, and the people on the other side aren't coming to it necessarily from a religious perspective, right? Like Amy Madonna didn't go and say, my religion requires me to do this, or I get a special privilege because it's from my religious perspective. It's often pushing back against non-religious activity or beliefs or whatever. Some of them might be motivated by religion, but it is harder for them to use RFRA in that way. So it's really designed to protect religion, not the opposite, the way it's written.
I would add too that this is the moral question that I'm often engaging with people of faith, right? Is religious imposition, which is what I'm beginning to call it, not religious freedom and not religious exemption, but religious imposition, justifiable under any condition, right? And I think that from these examples that we've seen, we don't want to till any soil where religious imposition is justifiable because it's an imposition, right? And that, to me, contradicts the values and ideals that we uplift as a nation around religious plurality, et cetera, or the ability to not be religious and have that be okay. So, but it's a tricky kind of question, and many people have cited the tension there. So I just wanted to add that.
I want to add to that as well. The way that the bill was drafted tries to, again, restore that balance about individual practice, right, individual right of religious exercise, with the responsibilities we have as citizens in a nation, and so the rights of the collective, and to not be your right of religious exercise, your right of any exercise, and having that That inflicts on me. Playing loud music at night in the middle of a condo complex starts to impact on my ability to get my kids to sleep, right? I mean, on a very kind of elementary level here. But the reason why we then crafted legislation as we did was to recognize that there are areas to preserve RFRA itself, not just repeal it, but to preserve it. And then focus on those 6 areas that I articulated before, that's in some of the documents that you've got, as well as specify that RFRA can be used only when a government is a party. To try to get back to the impact of the Constitution about the limitations on government action. And restore the fact that this is about government infringement and not to be used as a way to, and again, it's federal law, so a lot of the actions that you've heard about are going to be impacts of states, but this legislation can be used as a model to be drafted in other states across the country. But when you are seeing that state action, and where a lot of these examples impact state law, not federal law, but to try to make sure that, again, we strike this balance so that you can have your right. But when it comes to the use of federal taxpayer dollars, if a church wants to continue to exercise and say it is in our religious beliefs that we are only going to place adoptions with same-sex couples, go ahead and do that. That's philanthropic dollars, your own private dollars. You can do that under this legislation. Use of taxpayer dollars, you can't. Because we're not going to allow the use of taxpayer dollars for you to impact your religious belief on the values of the parent and the benefit of the child. And so it's the premise of this, I think, is simple. Do no harm. The nuance of this does get complicated, but it does seek to strike that balance of saying, yeah, we are trying to preserve this individual right. But limit that up until you do harm, right? So there's going to be some rub there, but it's until you harm, your exercise starts harming the rights of others.
I think you had your hand, and then we're almost at time, so it should be the last 2 questions. Yes.
Okay, so if there are 2 religious organizations that are doing kind of the opposite practices, can both of them use RFRA in different ways? Like if there are 2 Catholic hospitals, like the example you were giving, and one of them is providing medical pregnancy terminations and the other one is not, can they both use RFRA if they're like of the same sect of religion? I don't know if I'm phrasing that. Like if 2 religious organizations of the same religion are doing opposite
Interpretations.
Opposite interpretations, can they both use RFRA?
I think under current law, are the 2 institutions that are under the same sect, are they owned by the same company? And are they operated under the same board and sort of procedures? Because I think that is actually where it comes down to, because each organization is able to define who are members in good standing, what its religious tenets and beliefs are, and how it operates. And I think in the Catholic context, I do think because of the ERDs, I think that there could be more of a push to be consistent, but I think that push would actually come from leaders in the Catholic Church rather than the government, because the government couldn't decide for them if they were being good Catholics. They would just have to take them at their word. That being said, if it's an affiliated hospital of a larger branch, and one branch is doing this and one branch is doing this, but they say they're all the same hospital, under the law, they're one person, all of those, and so they would have to do something consistent. But if they are not affiliated with each other and they're just their own individual religious entities, which is how the law would view them, absolutely they could have their own interpretation of RFRA.
Well, and I think it gets down to what is a strongly held belief. You have the doctrine, which would legitimize your conclusion. But if different people have different conclusions and each of those hospitals what they believed, the fact that they're in some sect one way or the other doesn't matter. I mean, there used to be a time when segregation, racial segregation, was preached from the pulpit. If you go back to the Loving v. Virginia case, the judge justified the continuation of the ban on racially mixed marriages on religion. I mean, he started quoting the Bible. And so if you move that up with a RFRA overhang, you can say that the people have a strongly held belief, and that's where you end up. You can have some in the same church with different strongly held beliefs. You would start off, I guess, with the church doctrine, but you can have a strongly held belief and try and get a religious exemption. Do you get? And then the problem with this is it's kind of self-certified. I have a strongly held belief, so I'm not subject to civil rights laws. If I'm running a restaurant, I serve who I want to serve. I got a strongly held belief, and I'm not going to serve certain people. What used to be a time where I didn't care what you think of blacks or people of another religion. You got to serve them, period. And if you don't, you're subject to the lawsuit. Now, well, if I really don't feel like it, do you get an exemption? Well, that's where do no harm comes in. You just can't deny people their civil right to come into a public accommodation.
Hi, James from Representative Houlihan's office. I just had a question about something that Representative Kennedy brought up, which was the idea that the Do No Harm Act would include a provision that says that RFRA is restricted only to private actors dealing with government actors. Could you talk about the case where two private actors are dealing with each other and how that would then be affected by this legislation? Like, would a private actor going to a Catholic hospital still be denied, contraceptives from that hospital or certain procedures because of that, their religious belief?
So RFRA as it stands and as it was passed is all about government action. So you have to point to some government action. Are they, can you say that the hospital is violating some sort of law, some sort of policy, some sort of regulation, something. So there has to be that rub in there, right? So the other thing that about RFRA is RFRA is really there. So RFRA applies to all federal laws and laws in D.C. for those of you who live in D.C. It doesn't mean that you can't get a religious exemption some other way, right? Like you can pass a statutory provision that gives you a religious exemption that might be, tailored to a way that a lot of people agree on. So RFRA isn't the only way to get a religious exemption. But actually, to be honest, the interpretations of RFRA are actually making it harder for anyone to trust a narrowly tailored exemption, because what happened in Hobby Lobby is they pointed to the accommodation, not saying looks like there was a good faith effort to make sure that people's religion were accommodated and we sort of gone through all that, but to say, well, if you gave it over here, you can give it to everyone, right? So like once you sort of get your nose in the door and you have like a little tiny exemption, it can blow up to be an exemption for everyone. So that's actually not your question, but I thought it was very important to sort of point out another damaging factor in RFRA. But yes, there has to be government action for RFRA to apply. So I think we're at time. And so thank you all for coming. I want to mention that the House Education and Labor Committee is having a hearing on the misuse of RFRA on Tuesday at 10:15 for those of you who are interested. And if you have any other questions, we're happy. Well, I'll speak for myself. I don't want to talk for everyone else, but happy to stand up here and chat with you all. Thanks.